We shall commence this module by studying about SEBI guideline on size, pricing on issue and promoter contribution. Financial markets have an important relationship with economic development. A company decides to issue securities for different reasons. The main reason being raising capital to meet its financial requirements, maybe for starting a venture, repaying debts, expansion and diversification. In India, a company planning to issue securities shall abide by relevant provisions of A. Securities Contract Regulation Act 1956, B. Securities Contract Regulation Rules 1957, C. Companies Act 2013 hereinafter referred to as the Act, and the Companies Prospectus and Allotment of Securities Rules 2014, D. Securities and Exchange Board of India Act 1992 and the rules and regulations made thereunder. After studying this module, you shall be able to know about the Security Exchange Board of India SEBI with respect to size, learn about the SEBI guidelines on pricing of the issue, understand the SEBI guideline relating to promoters' contribution. We shall now discuss the SEBI guideline with respect to size. The Security Exchange Board of India SEBI Act came into force on 30th January 1992, and with its establishment, all public issues are governed by the rules and regulations issued by SEBI. SEBI was formed to promote fair dealing in issue of securities and to ensure that the capital markets function efficiently, transparently and economically in the better interest of both the issuers and the investors. The promoters should be able to raise funds at a relatively low cost. At the same time, investors must be protected from unethical practices and their rights must be safeguarded so that there is a steady flow of savings into the market. There must be proper regulation and code of conduct and fair practice by intermediaries to make them competitive and professional. Under the umbrella of SEBI, companies issuing shares are free to fix the premium provided adequate disclosure is made in the offer documents. Focus being the greater investor protection, SEBI has become a vigilant watchdog. First is eligibility norms for companies issuing securities. The companies issuing securities offered through an offer document shall satisfy the following at the time of filling the draft offer document with SEBI and also at the time of filing the final offer document with the registrar of companies designated stock exchange. First, no issuer company shall make any public issue of securities unless a draft prospectus has been filed with the board through a merchant banker at least 30 days prior to the filing of the prospectus with the registrar of companies ROC. Second, no company shall make any public issue of securities unless it has made an application for listing of those securities in the stock exchanges. Third, no company shall make public or rights issue or an offer for sale of securities unless A. The company enters into an agreement with the depository for dematerialization of securities already issued or proposed to be issued to the public or existing shareholders. And B. The company gives an option to subscribers, shareholders, investors to receive the security certificates or hold securities in dematerialized form with a depository. Fourth, an unlisted company may make an initial public offering IPO of equity shares or any other security which may be converted into or exchanged with equity shares at a later date, only if it meets all the following conditions. Fifth, the company has net tangible assets of at least 3 crores in each of the preceding 3 full years of 12 months each. More than 50% is held in monetary assets. Sixth, provided that if more than 50% of the net tangible assets are held in monetary assets, the company has made firm commitments to deploy such excess monetary assets in its business project. Seventh, the company has a track record of distributable profits in terms of Section 205 of the Companies Act 1956 for at least 3 out of immediately preceding 5 years. Provided further that extraordinary items shall not be considered for calculating distributable profits in terms of Section 205 of Companies Act 1956. The company has a net worth of at least rupees 1 crore in each of the preceding 3 full years of 12 months each. First, in case the company has changed its name within the last 1 year, at least 50% of the revenue for the preceding 1 full year is earned by the company from the activity suggested by the new name. And second, the aggregate of the proposed issue and all previous issues made in the same financial year in terms of size. That is, offer through offer document plus firm allotment plus promoter's contribution through the offer document does not exceed 5 times its pre-issue net worth as per the audited balance sheet of the last financial year. Third, a listed company shall be eligible to make a public issue of equity shares or any other security which may be converted into or exchanged with equity shares at a later date, provided that the aggregate of the proposed issue and all previous issues made in the same financial year in terms of size, that is, offer through offer document plus firm allotment plus promoter's contribution through the offer document issue size does not exceed 5 times its pre-issue net worth as per the audited balance sheet of the last financial year. Fourth, exemption from eligibility norms in case of A. Private sector banks which has received license from the Reserve Bank of India. B. Public sector banks. C. An infrastructure company whose project has been appraised by a public financial institution PFI or Infrastructure Development Finance Corporation IDFC or Infrastructure Leasing and Financing Services Limited IL&FS or a bank which was earlier a PFI. Fourth, rights issue by a listed company. Fifth, no issuer company shall make a public issue or rights issue of convertible debt instruments unless conditions are also satisfied, as on date of filing of draft offer document with SEBI and also on the date of filing a final offer document with ROC designated stock exchange. A. Credit rating is obtained from at least one credit rating agency registered with the board and disclosed in the offer document. B. The company is not in the list of willful defaulters of RBI. C. The company is not in default of payment of interest or repayment of principal in respect of debentures issued to the public, if any, for a period of more than 6 months. We now move on to understand SEBI guideline on pricing of issue. Pricing by companies issuing securities. The companies eligible to make public issue can freely price their equity shares or any security convertible at later rate into equity shares in the cases. First, a listed company whose equity shares are listed on a stock exchange may freely price its equity shares and any security convertible into equity at a later date offered through a public or rights issue. Second, an unlisted company eligible to make a public issue and desirous of getting its securities listed on a recognized stock exchange pursuant to a public issue may freely price its equity shares or any securities convertible at a later date into equity shares. Third, an eligible infrastructure company shall be free to price its equity shares subject to the compliance with the disclosure norms as specified by SEBI from time to time. Fourth, the banks, whether public sector or private sector, may freely price their issue of equity shares or any securities convertible at a later date into equity share subject to approval by the RBI. Fifth, any unlisted company or a listed company making a public issue of equity shares or securities convertible at a later date into equity shares may issue such securities to applicants in the firm allotment category at a price different from the price at which the net offer to the public is made, provided that the price at which the security is being offered to the applicants in firm allotment category is higher than the price at which securities are offered to public. Sixth, issuer company can mention a price band of 20% cap in the price band shall not be more than 20% of the floor price in the offer documents filed with the board, and the actual price can be determined at a later date before filing of the offer document with ROCs. Seventh, in case of public issue by listed issuer company, issue price or price band may not be disclosed in the draft prospectus filed with the board. Eighth, in case of a rights issue, issue price or price band may not be disclosed in the draft letter of offer filed with the board. The issue price may be determined anytime before fixation of the record date in consultation with the designated stock exchange. We shall now discuss the SEBI guideline on promoter contribution. Promoter's contribution in a public issue. First, in a public issue by an unlisted company, the promoters shall contribute not less than 20% of the post-issue capital. Second, the promoter's shareholding after offer for sale shall not be less than 20% of the post-issue capital. Third, in case of public issues by listed companies, the promoters shall participate either to the extent of 20% of the proposed issue or ensure post-issue shareholding to the extent of 20% of the post-issue capital. Fourth, in case of composite issues of a listed company, the promoter's contribution shall at the option of the promoters be either 20% of the proposed public issue or 20% of the post-issue capital. Fifth, promoters' participation in excess of the required minimum contribution to be treated as preferential allotment. Sixth, promoters shall bring in the full amount of the promoter's contribution including premium at least 1 day prior to the issue opening date 88, which shall be kept in an escrow account with a scheduled commercial bank, and the said contribution amount shall be released to the company along with the public issue proceeds. Exemption from requirement of promoter's contribution. The requirement of promoter's contribution shall not be applicable. A. In case of public issue of securities by a company which has been listed on a stock exchange for at least 3 years and has a track record of dividend payment for at least 3 immediately preceding years. B. In case of companies where no identifiable promoter or promoter groups exist. C. In case of rights issues. Next is lock-in of minimum specified promoter's contribution in public issues. In case of any issue of capital to the public, the minimum promoter's contribution shall be locked in for a period of 3 years. The lock-in from the date of allotment in the proposed public issue and the last of the lock-in shall be reckoned as 3 years from the date of commencement of commercial production or the date of allotment in the public issue, whichever is later. We shall now recapitulate what we have learned so far. The Security Exchange Board of India (SEBI) Act came into force on 30th January 1992, and with its establishment, all public issues are governed by the rules and regulations issued by SEBI. Under the umbrella of SEBI, companies issuing shares are free to fix the premium provided adequate disclosure is made in the offer documents. Focus being the greater investor protection, SEBI has become a vigilant watchdog. No issuer company shall make any public issue of securities unless a draft prospectus has been filed with the board through a merchant banker at least 30 days prior to the filing of the prospectus with the registrar of companies. The companies eligible to make public issue can freely price their equity shares or any security convertible at later date into equity shares. An unlisted company eligible to make a public issue and desirous of getting its securities listed on a recognized stock exchange pursuant to a public issue may freely price its equity shares or any securities convertible at a later date into equity shares. An eligible infrastructure company shall be free to price its equity shares subject to the compliance with the disclosure norms as specified by SEBI from time to time. In a public issue by an unlisted company, the promoters shall contribute not less than 20% of the post-issue capital. The promoters' shareholding after offer for sale shall not be less than 20% of the post-issue capital.